And on today's show, why calling yourself an expert may increase punitive damages. Part 4 of this week's series on protecting your practice with best practices with prosecuting insurance attorney Ilya Lirma. Hi everyone, I'm Steve Savant, syndicated financial columnist and contributing author to Pec Room Technician in Innsbruck. Let's get down to business. Well, welcome to day 4, Ilya.
Day 4.
I have to tell you, I'm still struggling with, should I bet a captive agent or an independent agent from yesterday's show? At the very end, I'm thinking, well, is there any real advantage to that?
Well, a lot of it depends on the position of the particular professional. Some would say there's an advantage to being a captive agent because you're familiar with one insurance company and all of their lines of products. So you have an in-depth knowledge of the various product lines they offer. Whereas an independent agent, you've got to know multiple agencies, you have to know multiple products, different coverages, different policy language, and it becomes a much more difficult task. But to the right producer, they would be able to judge their own character disposition to figure out where they're better suited. We're
talking about how we hold ourselves out in the public domain. Okay, LinkedIn is a wonderful social media, but I've also known that there are psychopathic liars out there that are talking about their area of expertise. This could be a problem if something goes south in their relationship with their client.
Oh, absolutely.
Talk about this, because I see this all the time. Expertise, and I mean they're using huge major league adjectives that are promoting their area of specificity, right? I think that's a problem. Talk to me about that.
It's absolutely a problem. And make no mistake, those LinkedIn profiles and Facebook profiles and your advertising materials, anything that you use to promote business in your practice is going to be used by a good insurance attorney. They're going to want to discover all of those materials. They'll probably download them and print them and store them before you even know that there's a claim. And so when you have your diplomas on the wall and you have the nice picture of you in a suit and you talk about your number of years representing this insurance company, understand that what you're doing is soliciting business from the general public, and you're using that relationship that we talked about in the earlier show. You're using that relationship to grow your business, but you can't now change the relationship and just use that expertise to solicit the business and then say hands off, hey, all I do is sell insurance, I don't know anything about anything. And it's really damaging to an insurance professional when they've dedicated 20 or 30 years to promoting themselves, this image as an expert, and with all their diplomas and the alphabet soup after their name of all these
credentials,
of all of their credentials, and then they have to say in deposition, well, I don't really know what that means. I've had insurance professionals who've been licensed for years who can't define the term liability without using liability in the sentence, and that's scary.
Well, I'm just trying to think of all the credentials in our business, whether it's CLU, CHFC, CFP, CPA, JD, MBA, you know. We put these behind our name to give us super validation that we're really something above the normal, average agent or the average advisor. And we're doing it because we took the course, we passed the test, and we think that is a little more valuable. I want to go beyond even credentials on my question to you, Ilya. I'm asking now, I'm out there on LinkedIn saying, I am a long-term care expert. I am a retirement expert. I'm a estate planning expert. I'm a tax advisor expert, and I'm not a CPA. I'm just thinking, because it's out there.
Absolutely.
Talk a little bit about that.
Well, imagine how you're going to be cross-examined when you have a client who maybe was a long-term care patient and a candidate for a good annuity that you missed, and yet your LinkedIn profile has you as an annuity expert. So how are you going to be able to answer the question when you're being cross-examined? Well, isn't this your LinkedIn profile? And they go down the litany of all of your expertise, and all of a sudden now you're trying to pull away from those things that you were promoting yourself. And understand that when you're suing an insurance producer, again, you go back to the relationship. It's not single transaction. It's not just this one-time event. because these are relationships that in your industry, in financial planning, you are constantly talking about cultivating relationship. And so it's an ongoing evolution of relationship with that client. So if you have 20 years of history of trying to develop this credibility with your client, and they come to you repeatedly over and over as their advisor, you can't then step away and say, gee, I just really don't know anything about that, because it completely destroys your credibility when you're being examined as a witness, either in deposition or on the stand.
Well, I have to say is then maybe humility may be the better way to go on this, and just you're talking about a general practice, a general standing, and not holding yourself out in any one area of expertise.
No, I've seen some insurance professionals talk about whether or not they should actually give recommendations, and maybe we should just be more order takers. But order takers are what the internet is for. And people who know what they want, they're welcome to use the internet. They're coming to you for professional counsel. And if you're going to give that and you're going to hold yourself out as an expert, then live up to it. Deal with the consequences if you've committed an error. But if you're going to hold yourself out as a financial expert, that means you're higher stakes. And that means you are instilling that credibility in the rest of the public and your clients, and you're subject to greater risk. So that means you actually have to do the work of educating yourself about how your insurance products work, et cetera.
Well, when we come back from the break, I want to go down this road with Elia on the issue of holding yourself out as the quarterback of your entire client's concerns. I mean, that is a big PR out on LinkedIn. When we come back, we're going to go on right down this subject.
Back in the day, life insurance professionals were called field underwriters. Then, carriers trained their field force in the basics of life insurance underwriting. Today, the insurance industry doesn't educate the agent population as they once did. But now you can have the Informed Risk Guide at your fingertips so you can illustrate a reasonable rate class for your life insurance prospects. Just request your copy of the Informed Risk Guide at downtobusiness.ashbrokerage.com. It's free from Ash Brokerage, the practice enhancement company.
Well, welcome back to our second segment. Elia, I want to ask you this because a lot of people hold themselves out as the quarterback of their clients' concerns. They're the CFO of their clients' concerns. They're really running a team. They collected all the team members. This guy does taxes. This guy's the legal eagle. This person's the trust officer. This is the person that does securities. This is the person that does the indemnification insurance. But I'm actually picking and choosing who joins the team, and I'm running the show. I am the quarterback, and I've even told my client I'm running the show for them. I'm their CFO. So, I'm the kind of their chief financial officer. Is that an issue?
Absolutely. And the reason is the law recognizes that when you adopt a duty, whether it's required of you or it's volitional, when you adopt a duty, you better live up to it. And that's effectively where your exposure for holding yourself out as an expert or any type of coordinator, you have to make sure that you actually take the steps to ensure that the people on your team are meeting their obligations, that they're qualified, that they're well-credentialed, that they're skilled. And you've adopted that responsibility by holding yourself out to the public. Again, encouraging that relationship outside for them to come in and grow your business. They're coming to you as the professional on your recommendations. You can't then turn around and say, gee, I didn't have any idea this person wasn't qualified, because you took on that responsibility when you held out yourself as that coordinator.
Well, you just gave me the idea. You need to vet guys that you're bringing on your team to help your client. If you have a substantial client, wealthy or affluent, and you're recruiting CPAs, attorneys, trust officers, people who do the indemnification, property casualty, other people doing their retirement, people maybe a subset of long-term care because it's becoming more specific as an expertise issue. We're bringing exposure because we're the ones that brought them in, and we didn't vet these guys.
Correct.
I mean, that's a problem.
Absolutely.
Well, and I'm thinking of the old idea, I'm building a house, I hire a general contractor. I like him, he's doing a great job, but the electrician is the one that did the wrong. But he's a subcontractor.
Correct.
The subcontractor is one thing, but I'm suing the general contractor. He's the one, right? I mean, this is basically...
Exactly. And there's an enormous body of law that goes all the way back to common law talking about vicarious liability, and the vicarious liability you may have for any employees, independent agents, anything like that. As a matter of fact, many years ago, one of the large carriers, I won't say who, But one of the large carriers began to categorize its captive agents as independent agents, and they started to have these independent agent agreements. They were effectively trying to distance themselves, the company, from the acts of their own agents.
Even though they were career agents.
Even though they were career agents, even though they're outside of their office bore the logo that everybody recognized, the materials had the logo, the policies they were allowed to sell were only for that one insurance company. Because you have to remember, it's all about appearances. And if it looks to your client like this person is working for you, working with you, working on your behalf for them, then you become, you bear the exposure the same as if you'd committed the offense yourself.
Well, I'm sorry, but did that legal maneuver work?
Absolutely.
Did it work
for them? No.
Yeah,
Oh,
it did.
no.
So
it didn't work
the
at
law
all.
saw past that.
Absolutely.
And said, these people are W-2s. I don't care what you call yourself. These are career agents.
Right.
Well,
and fortunately, they reverted back to calling them captive agents.
Well,
But it was a nice
only
little.
after.
It was a nice little experiment that they tried to separate themselves.
So you
from
are
it.
liable for people you promote to join your team and help your client out.
Sure.
Okay. I belong, and just many of us belong to really good study groups where we have people that are expertise. They may not be getting in front of our client, but I'm going back to my study group CPA. He's a gun in taxes, especially in product taxation. I go back to him and I say, hey, I got this client out, and he tells me something. I take it to the bank. He's got the credentials. He's been in my group. I've never seen him fail me. I go out there and find out in this area that he just addressed, it was not right. And I already put this out because my study group member told me that was it, and I relied on him. He's never had any problems before. Is that an issue for me now?
Well, it is, absolutely, especially if you know about it and then do nothing to correct it.
Okay, well, let's go down that straight. Okay, this is a perfect example. I discover, oh my goodness, that is not the case. I go back to my study group member. He finds out, oh my gosh, he made a mistake. Can I still remedy that? Is it possible to remedy? Because they actually made the sale or the purchase of the product based on that recommendation on his tax expertise.
Absolutely. And the first thing you should do is notify your client and let them know that the information that they may have relied to make this purchase was based on some faulty information. You may still recommend the product, you may still encourage them to purchase, but you have to give them the opportunity to perhaps look at other products that may be more suitable. But if you know and you've left that unaddressed, that's a potential area of exposure. That's a huge pitfall for you if the client finds out about it.
Well, I like to be more proactive, and I want to get into this tomorrow because one of our big sins in the advisory community is when we do find out we made a mistake, and we found this out before the client did, we're still not calling up. Or the reverse is, my client found out about it and I'm not calling him or her back. When we come back tomorrow, we're going to talk all about this. That's all the time we have for today's show. Remember, before moving forward with any of the ideas you hear on our show, always consult your tax advisor, legal counsel, and your broker-dealer compliance officer, because I don't practice any of those. I got that on film file. And if you missed any episode, just hop out to our site, downtobusiness.ashbrokerage.com, and remember, you could be wiser as an Ash Brokerage advisor. I'm Steve Savant. We'll see you tomorrow.